This is Mike DelSignore. Today's video will talk about what happens if you're arrested for OUI. The case is going to be heard in Dudley District Court, and it's your second offense. Now, second offense OUI, misdemeanor offense, often doesn't involve jail time, but usually doesn't. Keep those two things in mind. The license loss can be confusing and complicated. So you want to understand that right away. First off, if you have a prior offense between 2011 and 2019, that may allow you to vacate that conviction and bring your current charge down to a first offense. I had a client, OUI second in Dudley, went to Leominster, vacated his first offense, got a not guilty on the Dudley case and the Leominster case. He had no OUIs. It's happened a few times where clients come to me with 2 DUIs and left with none. I've had situations where the original case, they come to me, isn't great. They may resolve it, and sometimes we undo the other case and make that a first offense. So if you did take a breath test, point that out right away. Make sure that is known, so potentially you can file a motion, get rid of that charge. That's step one. If there is no motion to vacate, or if you refused on your first offense, this offense will have the following license consequences. If you took a breath test, it was over 0.08, you're just looking at a 30-day suspension. After 30 days, you can get your full license back. Now, cases can be won with breath test evidence. There's a lot of ways to get these tests excluded from evidence, so don't assume you can't win the case if there is a breath test in the case. If you refused, you're looking at a 3-year suspension. Now, if your 2 OUIs are more than 10 years apart, you have the ability to get what's known as a Cahill resolution on the case. So with this Cahill resolution, you can get back on the road if you refuse the breath test prior to 3 years with an interlock device in your car. Now, when you admit to an OUI or found guilty and you get a Cahill, you're still looking at a long period of time with the interlock device. Those devices aren't easy to use. You have to comply with a lot of rigorous rules. So, but you are allowed to drive. If your OUIs are within 10 years and you refuse, the only way to get your license back is essentially a not guilty after trial. There is an appeal to the RMV, but that's highly unlikely to be successful. So realistically, you must win the case. Otherwise, you're not driving for 3 years. And I should add, not only must you win the case, but the judge has to approve a motion to reinstate your license. Normally, they do. In some cases, they may not, but in most cases, not guilty verdict, the motion to reinstate the license would generally be approved. So second offense OUI, a judge or jury is not supposed to consider the prior offense. So that's not considered in evidence. They don't assume you're guilty because you did this before. So the keys to a defense, we try to minimize claims of bad driving, find ways to show that the field sobriety tests don't demonstrate impairment, that any deviation from perfection or how you're supposed to perform the test is explained by other factors, maybe confusing instructions, weather conditions, road conditions, medical history, a prior injury. So there's a lot of ways to say that these tests don't add up to impairment. And a lot of times they're a major aspect of the Commonwealth's case. And if they're not reliable, if they don't really show impairment, that can raise reasonable doubt. I had a person that really wasn't a good candidate for the test. I asked the officer, I had a trial this week. I said, when you study these tests, you don't have people in my client's shoes who you're testing to see how they perform on these tests after drinking. So you don't know. This isn't an exact science. You make general assumptions, but if someone has unique medical condition, unique circumstances, they're older, they may not be a great candidate for these tests. And sometimes officers will acknowledge there's other tests that weren't given, like an alphabet or number counting, that could have been useful. So keep in mind, you're arrested for OUI. It's a high burden of proof to prove the case beyond a reasonable doubt. That's the standard of proof. Government needs a lot of evidence to get to that point. So these subjective exercises, often there's not enough to meet that high burden. Your first court date is going to be your arraignment. After your arraignment, you'll be down for pretrial. Generally, on a second OUI, you'll be released on your promise to appear at court. However, if there's a high breathalyzer, the cases are close together in time, there could be a condition of alcohol-free. with any second offense, I always recommend my clients do alcohol treatment. It's never going to be used against you, only help the case, help get the minimum possible punishment if you're found guilty after trial. So if you have questions about a second offense and it's going to be heard in Dudley District Court, reach out to me. I handle OUI cases all over Massachusetts. Be happy to help you. My name is Mike DelSignore. Call, text anytime, 781-686-5924.